Welcome everybody. My name is Francesco Sindico. I am the co-director of the Strathclyde Center for Environmental Law and Governance. And it's a real pleasure to welcome you all to our third center biannual guest lecture. It's a very busy period for our center. Next week we have what we have called the Festival of Environmental Law and Governance, which is becoming a marathon, I think, on environmental law and governance. I hope to see many of you in that occasion. But as I said, today we're here for our SCELG biannual guest lecture. This is our third edition. We have had two fantastic editions in 2013 and in 2015. In 2013, we were lucky enough to have Professor Chen Bao-Qin from Wuhan University talking about environmental law in China. 2 years ago, we had Professor Gabriel Eckstein from Texas A&M University, who talked about international water law and transboundary aquifers. And it was then that we devised a roundtable format, if you want, where the keynote then gave the floor to two experts, and then opened it to a further debate, which is what we're going to do also today. But today we are really lucky. We are honored to have Professor Andre Nollkaemper with us. Professor Andre Nollkaemper is a Dean and Professor of Public International Law at Amsterdam Law School, at the UvA, at the University of Amsterdam. He is the principal investigator of an ERC project called SHARES, which I'm sure we'll all know more about today. And he's also the advisor of another ERC project, the one that our colleague Elisa Morgera runs here at the Strathclyde Center for Environmental Law and Governance, the Benelux project. Andrea is also the president of the European Society of International Law, so I'm afraid you'll see some of us in Naples in a few months as well. And as I said, Andrea's name for us who do public international law, who even do international environmental law, is a well-known name, is somebody who we have read, who we have followed, and it gives me a really, really true pleasure to have him and to welcome him at the center. And I hope that he can come again and further collaborate, not just with the project, but with the center as such. So before I give you the floor, just a few words on how the next hours will proceed. So Andrea will have 45 minutes to give his guest lecture, his presentation. I will then ask Professor Ellen Hay and Professor Elisa Morgera to join us at the table. I will briefly introduce them, and then both Ellen and Elisa will give a few comments they will discuss on the presentation that Andre Nollkaemper just made. I will then open it to the floor, and I'm really keen to get as many comments, as many questions as possible. I will try to be the fairest but the strictest chair as possible, so really to give you the opportunity to contribute to the debate. In the previous editions, that, including the guest lecture, but really the debate was one of the most enjoyable parts. We will then have the opportunity to mingle and to get to know each other even better, over drinks at the end of the session. So without further ado, I give the floor to Professor Andre Nollkaemper.
All right, ladies and gentlemen, it's my great pleasure to be here and to deliver the lecture. I thank the university for inviting me. I thank Elisa in particular. It's always a pleasure to work with her on the project. Now, the topic of my talk stems from the ERC project that I've run for the past 5 years. It's done and over. So I'm now in this period where I still have to wrap up to put together my final thoughts on what has emerged from those 5 years. And that actually is a very exciting time on almost as exciting as the research itself. Because now it's time to bring together what conclusions can we actually draw. So today I will speak on one aspect, and one aspect only. There are many different avenues for looking at shared responsibility. But I will look in particular at a tension that is inherent in the notion of shared responsibility. Namely the tension that while sharing of responsibility generally is a positive phenomenon that can help strengthen environmental governance, it also has the risk of resulting in a diffusion of responsibility, as a result of which it may become unclear who is responsible for what. So briefly, with the concept of shared responsibility, I refer to the principle that all actors who contribute to environmental harm are responsible for the consequences. All actors who contribute to environmental harm are responsible for the consequences. So, framed in this way, this sounds like a truism. It sounds like common sense. Of course, it has the same ring as the polluter pays principle. Of course, anyone who pollutes should eventually pay. So whether and how actors indeed share responsibility for environmental harm is key to global environmental governance. Whether you look at fisheries, marine pollution, migratory species, or climate change. In all cases, the question, do all actors who contribute to the harm eventually share responsibility, is fundamental to the legal arrangements and to the outcomes. So in climate change, clearly, there are many different states and non-state actors who contribute directly or indirectly to climate change. In a way, the entire question of global environmental climate law is about the question, do all these actors indeed have to share in the responsibility for harm? Now, when we start to think more closely about the problem of shared responsibility, some of the initial common sense idea, common sense in terms, of course this is a good idea, starts to get more complex. So one question is, for what acts do states or organizations actually share responsibility? Is it only for the actual act of pollution or degradation? So only the states who actually, by engaging in fisheries, deplete fish stocks? Or is it also states that collaborate, that participate, that act in concert with the states who actually take the fish or pollute the environment? So that's a fundamental question to which I will return. What is the type of conduct that triggers responsibility? But the more fundamental question that I want to put on the table is whether shared responsibility always is a solution. Is it necessarily a positive feature? So in my talk, I will argue that at least in some cases and at least under some conditions, sharing of responsibility may actually lead to a responsibility gap, because it may make it unclear who is responsible for what. So my talk will proceed in 5 parts. I will first say a few words about the type of activities, the type of policies that trigger the need for shared responsibility. In the second part, I will briefly put on the table the dominant principle in the law of responsibility, which is not shared responsibility, but rather independent responsibility. And I will argue why that is problematic. Then I will explain why shared responsibility has at least the promise and the potential to bring a solution to global environmental governance. And then in the fourth part I will come to my problem of diffusion. By way of conclusion, I then, in order not to end on a too negative note, I will then identify some ways forward that might provide ways out of the responsibility gaps emerging from the diffusion of responsibility. Good, let me start by identifying the two situations where we need something like shared responsibility. So these are well-known scenarios. The first is what I call cumulative environmental harm. So a typical example is transboundary water pollution or transboundary air pollution, where multiple states or non-state actors, I'll leave aside for the moment the question of actors, whether they are states or others, where multiple states, each independently from each other, emit pollutants in the environment. Another example would be fisheries, where some flag states are responsible for the depletion of fish stocks, and at the same time some coastal states might also be responsible for independent failures to take action under their international obligations. And yet another example would be under the law relating to migratory species. If migratory birds move through different countries, and each of those countries, independently from each other, fails to take the measures required under the agreements pertaining to migratory species, then obviously harm will result, and each of the states independently will be responsible. So in these scenarios, we can say that all of the individual states share responsibility for independent wrongdoing. Now in the second category, and this is the one in which I'm, for the purposes of today, more interested. The environmental harm arises out of joint or concerted action. Concerted action then means that states or all actors jointly coordinate, plan or carry out a particular action with a view to achieve a particular outcome. Sometimes this requires or involves an agreement. Sometimes it is coordination through informal means. Sometimes it's through an organization. Sometimes it's ad hoc or informally. So clearly, this is a dominant feature of much of modern international environmental governance, both in terms of activities that lead to harm. Take two upstream states creating a dam in a river, creating downstream effects on the ecosystems, but mostly in terms of states and institutions getting together to try to manage, coordinate, protect the environment. Moreover, this is mostly now a matter of legal obligations, because there's a range of treaties, whether in the law of the sea or law of water courses or air pollution, where states are obliged to cooperate and engage in concerted action. Now the point is, and this is where I get to the heart of the matter, that while generally we tend to believe that cooperation, joint action, concerted action is a positive feature, and it is, it has to be, it also may result actually in harm. So just one or two examples. So one can think of a upstream, of a International River Commission that adopts, approves projects that create downstream negative, harmful effects. More commonly, we can think of states that have to act together to protect fish stocks, to protect the Wadden Sea, to protect the watercourse, but they fail to live up to their obligations. So there are many treaties that oblige states, whether together or whether in the context of international institutions, to achieve certain aims as a matter of obligation. So if states fail to do so, if the organizations fail to do so, harm will result. And then the question is, who of the states, which of the states, will actually be responsible under international law? So it is in those situations that the question of international responsibility arises. Now, those of you who have studied to some degree the law of international responsibility will know that the law of responsibility, as written down by the International Law Commission, has not been written with these type of situations in mind. Clearly, the entirety of the law of responsibility has been written from the angle of what I call independent responsibility. Meaning that each state is responsible on the basis of its own conduct and by reference to its own international obligations. This is the situation in general international law, and it's clear that international environmental law does not create an exception to this general principle. Now, this principle, of course, reflects practice, but it also rests on at least two solid foundations. The first foundation is what I would call methodological. It means that the relevant units of analysis in international law are individual states. So just like in the law of individual responsibility, we say that individuals are only responsible for their own action, not for the action of someone else. In the law of state responsibility, the unit of analysis is the sovereign state. And given the centrality of the sovereign state, the responsibility is to be assigned only to individual states. Now there's a normative twist to this, because just as we feel that in the law of individual responsibility it would not be fair, it would not be just to make an individual responsible for the conduct or omissions of someone else. Similarly, in international law, we feel, many feel, it would not be fair, it would not be just to make states responsible for the conduct of others. And this text is from the commentary on the articles on state responsibility adopted by the International Law Commission, and this leads through each and every article. It is also dominant in the case law, so cases like the East Timor case, Indonesia versus Australia, Portugal versus Australia, and the Nauru case, Nauru against Australia, where there were actually 3 states involved, Australia, United Kingdom and New Zealand. The court always has approached these cases through the lens of independent responsibility. The wrongfulness of each actor had to be determined on the basis of its own acts. Now, to be clear, this principle definitely is not irrelevant for international environmental law. There are many situations where this principle can do the trick. So in the cases of transboundary water pollution, where multiple upstream states would discharge pollutants in the river, under this principle you could assuming that the science is there and that causality will be proven. You can hold each state responsible for its own conduct. And key here is that under international law, the fact that you do something together does not release you from your own obligations. So even if states would act in the framework of an international institution like a fisheries organization or a watercourse commission, they still would be bound by their own individual obligations. So an interesting application that also shows how this can be relevant is the famous case, I could say, of Urgenda versus the Netherlands. That still stands as a sweeping case on the obligations of individual states. So an NGO sued the Netherlands in a Dutch court for its failure to take proper action to reduce emissions. The Netherlands said, well, we are just one of the players here and we are a very small player. So we are not a proper state to bring to a court. And the court said that the single circumstance that the Dutch emission only constitutes a minor contribution to the global emissions, and one can read between the lines, and the fact that there are many, many other states involved, does not alter the state's obligation to exercise care towards third party, and eventually did not undermine the responsibility of the Netherlands. So in these cases, the principle and the law of responsibility operate quite unproblematic. However, there are clearly situations where the principle of independent responsibility does not do the trick. And there are at least two of these situations that we need to highlight. One is where there are insurmountable problems of causation. So situations where you cannot determine who of a multiplicity of states caused what harm. So in the Urgenda case, the case was not argued based on the connection between omissions and harm. It simply was based on the fact that the Netherlands didn't do enough, whatever contribution they had made to whatever harm. But if you argue a case starting from the harm, then you need to connect acts and omission to the harm. And if you have multiple actors, you are in serious difficulties, because the law of causation in international law is definitely underdeveloped. So that's one situation where this principle doesn't really work. The second is, as I mentioned earlier, in cases of concerted action. When multiple states all do a little bit something, but no one actually, or only one of them, engages in the harmful action. So the example here again would be a regional fisheries management organization that would fail to comply with its obligations. The failure can only be explained by the acts or omissions of many, but none of the individual states may breach its individual obligations. So these cases show that the law of, or the principle of independent responsibility has the tendency to reduce complex situations of cooperation into rather simple structures of individual or bilateral action. So the law of responsibility then does not match the complexity or the structure of cooperation. So the larger point here is that a system of responsibility that would disaggregate responsibility into individual cases of wrongdoing does not connect well to the structure of cooperation. And this may then undermine the key benefits of the law of responsibility. And of course we have to keep in mind throughout my lecture that the law of responsibility has key benefits, at least two. One being that the law of responsibility requires, demands a return to legality. So in a situation where a state or other actor breaches its obligation, the law of responsibility requires cessation of the wrongful act. So in terms of a rule of law perspective, in terms of compliance, in terms of effectiveness, responsibility is key to make actors do what they were supposed to do. And of course the second benefit of the law of responsibility is to protect injured parties. Clearly so in situations like transboundary air pollution, transboundary water pollution, where there are actually victim states and where it is the law of responsibility that has the task to make sure that the injured party is made whole again. Now, if the law of responsibility does not connect well to the structure of cooperation, then these key benefits will remain unfulfilled. So it's therefore, well, let me make one more point. One other reason why this situation, so the situation of independent responsibility, is unsatisfactory in situations of cooperation or multiple actors, is that it tends to be very unjust between the multiple parties who are accused of wrongdoing. Because if it's only one state out of many that is held responsible, it is that state that will bear the consequences and perhaps has to pay compensation. So this was exactly the case in the Nauru case, when Nauru sued Australia for its role in the exploitation of the natural resources on Nauru. Australia said it was not just us, because we were acting together with the United Kingdom and New Zealand. The court said that this was not a reason not to bring a case against Australia alone. But the open question, that was never answered by the court, but Judge Ago gave a very strong separate opinion on this. The open question is whether it would have been just if Australia alone would have had to pay compensation to Nauru for the full amount without the United Kingdom, without New Zealand providing their share. So the law of responsibility, this is the thought, needs to connect to these situations where there are multiple actors and need to allow, provide for arrangements that would channel responsibility to multiple states. Now, on that point, I then arrive at the principle of shared responsibility, which somehow then would look like the solution for this. So at this stage, I need to define more in detail what I mean with shared responsibility. So this is a definition that might strike you as sort of common sense, but I can assure you that the SHARES ERC team has spent at least 4 years to come up with this definition. Sometimes only words change, but this is the end result. So the idea is, and I guess I have 4 important points here. Shared responsibility refers to a situation when there are multiple actors, and the nature of the actor here is not relevant, contributes to a single harmful outcome, and international law distributes the legal responsibility for the harmful outcome between the contributing actors. So let me highlight 2 points in this definition here. One is that I will look here, and that the whole project looks to situations where there is a single harmful outcome. Because clearly there are many situations where acts or omission of states leads to environmental degradation which are not connected. But the true legal challenge, and that is the reason for this focus, arises when acts or omissions of multiple states lead to a single harm. Whether it's depletion of a particular fish stock or a single harm in a watercourse in one particular downstream state, or whether it's a particular migratory species which is exhausted. The other important point is that the responsibility is distributed between the contributing actors. So it is, one can speak about this as collective responsibility, but it is not collective in the sense that it is not one collective that is responsible, but all parts of the collective are responsible. So if states act together in a regional fisheries management organization and somehow harm would occur, you might argue that the organization, assuming that there's legal personality, would be responsible, full stop, end of the matter. That for me would not be shared responsibility. It only would be shared when, apart from the responsibility of the organization, the contributing states would actually share in the responsibility. But critically, the fact that the responsibility is distributed to individual actors does not mean that these actors are unconnected, individual. The crux of the matter is that there's a relationship between these individual actors, and it's precisely that relationship between them that justifies the sharing of responsibility. And that relationship at least exists in two senses. One is that the conduct of one actor will be dependent or influenced or shaped by the conduct of others. So what one state may do under a particular treaty regime on climate change, marine pollution, will depend on what other actors are doing. The other sense in which there is a relationship is that, of course, together the actors can achieve more than they could have achieved alone. That, of course, is precisely the reason why they engage in concerted action. It is these relationships between the actors that justifies also in the normative sense the allocation of responsibility between the actors. Now, prima facie, it's clear that if we accept shared responsibility, this may provide important benefits for environmental governance. Because think back to what I said about the benefits of responsibility, benefits in terms of return to legality and compliance on the one hand, benefits in terms of protection of injured parties on the other. If these benefits are undermined by the principle of independent responsibility, one might think that the principle of shared responsibility would counteract that. Because all actors would be obliged to return to legality, and all actors would be obliged to provide compensation. Now, my argument is that while this in general is true, while these benefits in the abstract can be identified, there is a darker side to this, and this is the problem, the phenomenon of diffusion of responsibility that arises when states get together. I'm not sure why.
That's the dark side.
Yes, it is. The diffusion of responsibility, which is phrased here in a quote by the Dutch political scientist Mark Bovens, who argued that if responsibility for any given instance of conduct is scattered among more people, the discrete responsibility of every individual diminishes proportionately. So the underlying idea is that if we all are responsible, no one will be responsible. This dimension of responsibility is heavily influenced by the work of the American political scientist Dennis Thompson, who wrote a book on what he called the problem of many hands. He wrote this in the context of US government, the idea being that if within any organization the tasks and responsibility are divided over too many hands, eventually nothing is accomplished and no one will be responsible. And that's the same idea as the proposition by Mark Bovens. If you analyze this a bit further and you ask yourself why is it that shared responsibility that sounds like a good idea may result in diffusion, I guess there are two possible explanations. One is what I call normative, the other is more methodological. So the normative one is that responsibility is essentially a moral and a normative concept that requires that certain conditions are fulfilled. So any legal system attaches certain minimum criteria before one can be responsible. And the phenomenon that occurs in case of concerted action, cooperation, is that by spreading conduct over many different actors, the individual contributions by each actor become very small. And it may actually be too small to cross the line of illegality. And of course, the law of responsibility pitches the standards for illegality often pretty high. Just to give one example, the principle of complicity. Complicity, which is an archetypical concept of shared responsibility. That if you aid or assist someone else in the commission of a wrong, you are responsible yourself. But the law of responsibility has pitched that threshold for being responsible for complicity very, very high. So it's very well possible that multiple actors assist each other in committing a wrong without each of them committing the wrong itself. The second point, the second explanation of this, is what I called methodological. This is simply because it may be very difficult to determine the facts. And this brings us back to the problem of causation. So if you have multiple actors that together cause harm, take land-based marine pollution, where the sources come from many, many, many different places, and it's often very difficult to determine where a particular pollution originated, in which country, and from which actor. And of course, the more actors you have, the more difficult it gets to determine who did what. So to give one example outside the law of environmental governance, but the famous example that I always cite here is the Saddam Hussein case, which originated in the US attack on Iraq. And Saddam Hussein, before he was killed, sued 45 states, European states, for collaborating with the United States in overthrowing the Saddam Hussein regime. That case eventually went nowhere, because the court said that Hussein could not identify in any degree of detail which state did what and contributed to what part of the situation in Iraq. Now that type of problem might easily be transplanted to many situations of environmental governance. Looking at the problem of diffusion a bit more closely, there are 3 points that I need to highlight. One is that diffusion is not something that is out there or just happens. It is often designed. States construct their obligations in a way that may make it difficult to determine who is responsible for what. So obligations of cooperations, obligations to take joint action, of course are positive because of the aims they try to achieve. But they're framed in a way that makes it very difficult to determine who is responsible when something went wrong. So, as an example, the case in the International Court of Justice on nuclear proliferation against the brought by the Marshall Islands against the United Kingdom. That was a case based on the claim that the United Kingdom failed to perform its obligation to cooperate. And the big question, that of course was never answered by the court, is whether and how a court can determine whether one individual state failed to cooperate. Because the UK could always say, well, it was not us, we need more parties to cooperate. And of course that depends on the structure of obligations. It is also a matter of design because of the structure of the law of responsibility. Something that is often overlooked. Responsibility is seen often as a natural consequence of a breach of an obligation. But the law of responsibility itself is full of choices. Each and every article in the ILC articles on responsibility reflects a political choice to set the threshold for complicity or circumvention in a particular way. For instance, in domestic law, at least in states like the United States, there is a principle of joint and several responsibility. If you do things together, each of them can be jointly and severally responsible. In international law, we do not have that principle. And that, of course, is not a matter of oversight. It is a conscious choice, except rare instances like the Outer Space Treaty. That principle simply does not exist. So the diffusion that results is politically designed. Second feature when we analyze this. Diffusion of responsibility leads to what I would call a problem of blame games. It allows states to point to others for not fulfilling their obligations. In a way, the Uganda case against the Netherlands already showed that. When the Netherlands in defense said, well, it wasn't really us because the others were bigger contributors. So when a regional marine pollution treaty contains an obligation to cooperate, and states do actually cooperate in large numbers, and the results are not achieved, it is easy for states to put the blame to someone else, like also the United Kingdom did in the Marshall Islands case. Blaming also can occur when states act within the framework of international institutions. Because then, if the institution has legal personality, the states tend to say, it was not us, it was the organizations, and you cannot sue us alone. This is what was referred to by Jeremy Bentham as screens. States can then hide between the institutions. And clearly the law of responsibility accepts that mere membership of an organization, even mere voting in favor of a decision of an organization, even if that decision is wrongful, does not trigger the responsibility of the individual states. So in these situations, states can indeed hide behind the organizations. And all of this, of course, comes with costs. And paradoxically, these costs are, of course, the same cost as we initially had with the problem of independent responsibility. Because when responsibility is diffused, it means that it's more difficult to hold individual states responsible, and thereby also to require that states comply with their individual obligations. And likewise, it is more difficult for injured parties to find out who is responsible for what. Now, where do we go from there? If this analysis is correct, I believe that the same features that I identified as causes of diffusion also can be used to articulate possible solutions. So, in part, these, somewhat paradoxically, bring us back to making it easier to hold states individually responsible for their own conduct. So yes, it is easier when obligations are precise and detailed. Because the problem of diffusion arises in particular with obligations like cooperation, the obligation to undertake joint action. Once you specify specific emission standards, obligations to protect particular species by taking particular action, then there's no room for blaming someone else. It's just you who is responsible for the action. In that sense, the test for a workable system of responsibility eventually depends on the precision in the obligations. You could also say that the law of responsibility cannot achieve more than the primary obligations in the treaties allow for. A second critical point is data monitoring. I noticed that one of the causes of diffusion is that it may be very difficult to identify who did what. If you take the example of CITES, Convention on International Trade on Endangered Species, there we see that largely as a result of the work of NGOs, it is detailed in a high degree of specificity which state and which actors are involved in traffic of particular species. Under the long-range transparent air pollution regime in Europe, great progress has been made in the past decades in terms of monitoring of data of individual polluters. So the possibility of the law of responsibility to achieve its aims depends then in large part on basically on the science and the monitoring systems that allow the identification of individual polluters. And then thirdly, the law of responsibility simply works better, works easier in formalized structures. I have not highlighted that so much in my talk, but clearly the problem of diffusion is much bigger in case of informal cooperations, when for third parties it becomes very unclear to determine what actually were the rules and who did what. Formal organizations, so cooperation in formal international organizations that themselves are subject to international law, clearly makes that the law of responsibility operates better. These three avenues are in a way aimed at making it easier to identify individual actors for their role in environmental degradation. One can also be more ambitious. So one question is, shouldn't we have a rule that would say that if two states engage in a concerted action, both states would be responsible. And you cannot sort of hide yourself behind the other. In his third report, James Crawford actually suggested this and said when two actors engage in a common adventure, the victim should not be required to prove which particular damage was attributable to each of them. This is basically responsible for engaging in concerted action. But that proposal by Crawford was never taken up, and it is not in the final outcome of the International Law Commission, where there is no basis for holding a state responsible for acting in concert with others. Along a separate track, we have in the SHARES team be engaged in the past year in drafting actual principles of shared responsibility. So we have now 20 of them. And perhaps the most innovative one, I feel, is precisely this one, where we propose that there should be a principle in international law that makes states responsible when they engage in common action with others. And the other obvious principle which is lacking, which is related a bit, but it's slightly different, because it's more focused on reparation, is joint and several responsibility. So the Convention on Liability for Damage Caused by Space Objects provides for this. And this rule, of course, makes diffusion almost impossible, because every state will be responsible for the whole thing. Now, it is my tentative thought that the second principle is far beyond the horizon and will be highly controversial. The first one, based on the work of the ILC, may be within reach. But in either case, this is work that still has to be achieved, not necessarily in environmental law as such, but also at the level of general international law. Because if my talk, if I can infer one general conclusion of my talk, it is that the law of general, so the general international law of responsibility, continuously interacts with the specific law of international environmental treaties. And one cannot disconnect one from the other. The treaties have a fair little to say on responsibility, and you need the general law of responsibility. Similarly, as I've said, the general international law has fairly little to offer if the treaties do not provide for the specific obligations, if the treaties do not provide for proper arrangements for data monitoring and so on and so forth. So with these words, I would like to conclude. I'm happy to engage in a discussion, and I definitely will take forward any thoughts and comments, not only in this paper, but also in the very final formulation of the SHARES principles. So thank you very much.
Thank you very much, Andre. That was really fascinating. I didn't even need to give you the 5 minutes. I was so captured by it. So. But it's perfect timing as well. So I'd like to ask Professor Morgel and Professor Hay to join us here at the table. And I'll see if I can.
Maybe you could also leave the slides up, especially the last ones.
Okay, then
That
I
would
won't
help.
touch the light. Okay. So just a few words on introducing our two discussants. We have the pleasure of having with us Professor Ellen Hay from the Erasmus School of Law at the Erasmus University in Rotterdam. She's a professor of public international law, and for many of us who, again, have taught and practiced international environmental law, Ellen is very well known. And I was telling her how we at Strathclyde use her fantastic textbook, Advanced Introduction to International Environmental Law. You call it booklet, we call it fantastic textbook. So it's a real pleasure to have Ellen with us today. And the second discussant is Professor Lisa Morgera, co-director at the Strathclyde Center for Environmental and Governance and Professor of Global Environmental Law and Governance here at the law school. So I'll give both Ellen and Elisa time to get back with some comments, some points to Andre. I hope you don't mind, make 1 or 2 points myself, and then we'll allow Andrew to react immediately, and then I will definitely open it to the wider floor. So,
Can I come up there just a second?
Yes,
Just
whatever
all
you
my
prefer.
notes. Thank you so much for that introduction about what I keep calling a booklet, because it really is a booklet. It's a pleasure to be here. It's also a pleasure to comment on Andre's work, because although we live and work in the same country and very close to each other, we end up meeting each other abroad most often. Thank you for a fascinating, I think really thorough piece of deep thought work. And what I did, and I must confess that Andre did send me his notes, although we took his own arguments a bit further this afternoon. But what I started doing after I'd read your notes was going through these intellectual exercises and thinking, okay, so who would be held responsible? In taking some of the examples also that you referred to in the paper. And I basically, because that wasn't totally part of the thing, I came to the conclusion, okay, you've got a responsibility for the law on state responsibility to be amended and to introduce maybe this idea of shared responsibility. And then there's a responsibility for international environmental law, which you elaborated on more here. And now where is the, if I could go back to the previous slide. Detailing individual obligations. And that's what I focused on in preparing my comments. But I did the exercise, okay, so we have 2 states or more states cooperating, for example, in establishing MPAs under the Oslo-Paris Convention. And I thought, okay, so we have the MPA, is that contrary to international law? I'm not so sure. What would be contrary to international law? I suppose if some state were to enforce the MPA against a third state. Then I went on to think about nature conservation agreements. States cooperate. And yes, if we have proper monitoring, then we probably can hold a certain state responsible. If we don't have proper monitoring, we don't detail individual obligations, regardless of whether they cooperate or not. None of them are ever going to be held responsible. So increasingly I started thinking about, well, maybe detailing individual obligations, data monitoring, formalizing institutionalized cooperation, to come back to the MPA example, assuming OSPAR, the organization, had the power to enforce the MPA. Well, probably that would mean that the organization would be held responsible, but of course we all know that it's extremely difficult as a practical issue to hold the organization responsible. So I think all these points that Andre now nicely wrote out on a sheet are extremely important, but they're not only important for holding states accountable when they cooperate in any form or other, but they're extremely important for ensuring that states can be held responsible under international environmental law and international law in general, I would say. So I think that although intellectually and also practically, it's very interesting, and it's also important that this topic, and of course it's related to the project, gets presented as a problem of states sharing responsibility amongst themselves, and then all these problems arising of, who do we hold responsible, who do we hold accountable. But I think it's a more general problem in international law, where we need all of these, and also the law on state responsibility to be amended. But I think this part in fact, for the future of international environmental law, is probably more important if we want to hold any state or even other actors responsible. That was my contribution.
Thank you very much.
And thanks for making me think.
Can I ask
One more.
Elisa to come up?
So, first of all, I think my heartfelt thanks to Andre and Ellen for having accepted the invitation and for having shared with us their thoughts. I think this has been a tremendous afternoon, and there'll be much more thinking that will occur in our brains in the days and in the months to follow, I think. I haven't prepared detailed comments, but I will share some of the thinking that has been going on in the context of the Benelux project on some of the themes that Andre has identified, to see whether joining efforts we may be able to progress a bit in our thinking. And I think I'm particularly happy that Andre is here as also an advisor to the Benelux project, because to quote his own words, when we had our first workshop for our project, perhaps our two respective areas of research may be the two sides of the moon. And while Andre and Andre's team has been focusing on shared responsibility, within the Benelux team we have focused on fairly and equitably sharing benefits arising from different forms of international cooperation. So I think perhaps the commonality between the two projects is very much reflecting on the potential and the hope that we may have in the role of international law in fostering genuine, effective international cooperation, and at the same time trying to understand more systematically the dark sides, where things go wrong, where we have bottlenecks, and to what extent international law itself may be a solution in perhaps further developing in really serving those objectives of a heightened perhaps forms of international cooperation. And I think the aspects, perhaps I might follow Ellen's example and focus on this one slide, which reminds me very much of debates I've had until yesterday with my colleagues in the project about what we can realistically achieve with the clarification that we may bring with our own work, as well as with any recommendations that we may come up with in terms of perhaps policy and normative work. And one of the key challenges for us as lawyers who are interested in advancing genuine international cooperation through international law is exactly how can we deal with shortcomings of international law that are there by design, that are engineered by states or by some states with a view to shielding themselves from a particular commitment and endeavor in realizing and contributing to the realization of international objectives. And how do we deal with the political choices underlining the engineering by design? And I think, one of the things we've been discussing and attempting in the Benelux project has been that of saying, well, that is a job that lawyers should engage with, international lawyers perhaps more than we do already, but an endeavor in which we shouldn't be alone and where we should engage other disciplines that perhaps are more or have a longer history of dealing with power, with politics, with different elements that make and explain the law. The second, and I think the other aspect that I really liked among the many in Andre's presentation is that for how much disheartening it can be to come to the realization and to the understanding of why we have barriers there, that the very reason why we have international law is states coming together, and the very reason that international law falls short is when states come together to somehow engineer those limitations in that instrument, is a fundamental, then it can become a fundamental engine for finding solutions. And until we identify carefully and systematically those causes, we will remain far from finding solutions. Now, whatever solutions we may find, and I think we do have to think more ambitiously about perhaps short-term, more politically acceptable solutions, as well as perhaps less politically palatable solution, which may still be perhaps possible in the longer term, we have to think in terms of a series of options, and then the pros and cons of each option. And then for each solution, we already probably have to kind of engage in forward thinking about what will be the next problems that will come up once those solutions, if ever, are put into place. And I think any lawyer knows, I mean, national law is no different from international law, that the moment we put in place a legal instrument, we have other lawyers who look into loopholes and ways around it. So this is an ongoing thinking process. So the first point, probably the point I will spend the most time, is the idea of detailing individual obligations. And how do we do that? Do we do that through interpretation? Do we do that by progressively develop international law? And which actors will be doing that work or will be pushing for that work to happen? And this is one of the things that we have, the dynamics of an evolving interpretation of international law and its own limitations, the dynamics of progressive development of international law, once again are a matter, I think, not just for international lawyers alone to think about, but perhaps to engage with other colleagues in other disciplines to understand dynamics but also the possible implications of different legal developments. The second point about data monitoring, I also think it's increasingly interesting. It's an area, particularly with the development of big data, advancements in technology, perhaps the international climate change regime may be the most advanced regime in which to look at in terms of monitoring, reporting, and verification. It's an area where I think lawyers are challenged to work with other disciplines. The understanding of how data gathering, data comparison works, the technological advances that we can use is one aspect of it. I think the other aspect is, again, the power dynamics at play and the fact that we have not only information imbalances, but we have technological asymmetries out there. And if we do place more and more emphasis on data monitoring, we also have to factor in the different countries. Some countries will have an upper hand on this and others will not. And other international obligations that have to do with scientific cooperation, with technology transfer, with capacity building, will be equally important in really using this instrument for the genuine advancement of every state in fulfilling their respective responsibilities under international environmental law, rather than perhaps being used as an instrument that may advantage fairly or not some countries but leave others behind. And particularly where in an area such as international environmental law, where in certain key areas, if not perhaps as a general principle, we have the idea of common but differentiated responsibility. We have at the very core of many of the architecture of international environmental agreements the understanding that not all states have the same, have made the same contribution to global environmental challenges, and certainly not all states, and in fact a vast majority of states, do not have the same instruments to fulfill their obligations, and very much depend in doing so from the collaboration of other states. And the third point, which I also very much like, the idea of formalizing and further institutionalizing cooperation. This is something that is actually, to my mind at least, coming as one of the key interesting practical applications also of fair and equitable sharing of benefits. And again, it comes with its own challenges. I mean, there are good reasons why countries are resistant to further formalizing and institutionalizing cooperation, partly because that will facilitate a further understanding of their obligation and more monitoring of whether or not they are complying with, more perhaps on a kind of a nitty-gritty level, because that has costs, and we know we are all in a period of time where many traditionally donor countries may no longer be able to shoulder as much of the bill of international cooperation as they used to, or there may be political priorities that make it even more difficult for those countries to continue to do so. But also because that institutionalization at the international level means developing also the substantive law underlying that cooperation. And again, we would find the same obstacle of the underlying reluctance of some states that have engineered international law as we have it right now in a way that is there to exactly prevent that development from happening. The last point that I really will be thinking about and will be discussing tomorrow is the idea of, well, what can we learn from specific regimes in international law, and how much of that can and should be brought to the level of general international law. And while we understand that, of course, the two can exist without the other, the actual drawing of common ideas or key trends from specific regimes to the level of international, general international law is not an easy task, is again a task where many states may take issue with for reasons related to the different interests, the different areas of international, specialized areas of international law are catered for, and as we all know, not all specialized regimes have the same importance for different states. And for that very reason, different specialized regimes have their own idiosyncrasies, be that terms of application, be that institutional approaches, be that interpretative approaches. So those are, I think, at least in the Benelux project, very conceptually, I think, for the researcher, very hard barriers to overcome. And in overcoming them, there are, at the very least, there's a risk of exposing oneself to the risk of perhaps being an advocate more than a researcher. I don't think that is necessarily a problem, but it does pose perhaps a higher burden of proof, I think, in trying to take that path. And I will conclude perhaps with a question for Andres, something that again we have been discussing in the Benelux project, which is the question of framing international obligations, not only by states but also by other actors, and again how other disciplines have perhaps engaged with the idea of framing much more than lawyers. What is there for us to learn in terms of understanding the framing of international law and different framing processes? And that, to me, has very much to do with interpretation of international law, with progressive development, and it may perhaps allow Andre also to expand upon the role of non-state actors in his work. I think that will really be something that will be very interesting for us as well. So I'll leave it at that. Thank you.